General, the very eminent Dorcas Oduor, our first female Attorney General, and she instructs me to inform the court that she is here because Article 156, sub-article 6, enjoins the Attorney General to promote, protect, and uphold the rule of law and to defend the public interest. The people of Kenya have a public interest in the maintenance of a stable government and in the protection of the sovereignty of their republic. And that republic is underpinned by having continuity in the institutions of government, be they the legislature, be it the judiciary, or be it the executive. We shall be submitting that the public interest is in favor of an expeditious disposal of matters that affect the continuity of government and that imperil the stability of the state. And that human rights are not only accorded to individual applicants, they are also accorded to the collectivity called Kenya. And the people of Kenya, they also have human rights. I agree with my learned friend, Mr. Ngoya, who is a very eminent constitutional jurist and a practitioner of the constitutional law. I agree with him when he says the Constitution 2010 in many ways is transformative, has introduced more versatility in the protection of human rights. That is true. I also agree with him when he says that the Constitution must be construed in a manner to give full effect and protection to the rule of law and to human rights. But I further submit this, that the Constitution too must be interpreted so as not to create an absurdity. The Constitution must be construed so as not to create an absurdity or to put it in conflict with itself. What is the purpose of the Constitution? To establish the state. What is its further purpose? To provide for democratic government and to protect the rule of law and to protect human rights. These are not in contradistinction. These are not at war with each other. A stable government, a sovereign people, and human rights are not in conflict with each other. They are in harmony. It is the work of the court to interpret in order to create that harmony. When the court is invited to interpret the Constitution so as to create an absurdity, it must refuse to do so. This afternoon, you are being invited to interpret the Constitution to create an absurdity. Why is it an absurdity? The Deputy Chief Justice of the Republic of Kenya can swear in the President of the Republic of Kenya into office. What a huge power. What a huge authority. The Deputy Chief Justice of the Republic of Kenya can empanel a panel of judges, can appoint a tribunal to remove the president from office. What a huge responsibility. What huge authority. But wait a minute. The Deputy Chief Justice cannot assign duties to judges. Pray, my lords. What then does the Deputy Chief Justice deputize? What does she deputize? In many jurisdictions, like those referred to by the distinguished counsel on the other side, in many jurisdictions, including the United States, there is no office of Deputy Chief Justice. In the Supreme Court of the United States, there is the Chief Justice and Associate Justices. In Kenya, the drafters of our Constitution, and if I may say so myself with a bit of humility, I was one of the draftsmen. Knowing that in other countries there was no office of Deputy Chief Justice, decided in Kenya there shall be an office of Chief Justice to deputize the Chief Justice. In doing what? I'll be very brief. That is to be found in the Constitution itself and in the statute. And I think I will leave my learned friend, Mr. Ngobo, to deal with that. But let me, in the 2 minutes I've been granted by this gracious lady, make 1 point, 2 points. Beneficiaries of ex parte orders stand before this court and say, only they are entitled to ex parte orders. They are here to complain that they went before Judge Mongo, they went before Judge Muite, they got ex parte orders with finality, and that was okay. But when the Attorney General went ex parte, and all her prayers were refused, except the prayer to send the matter to the Chief Justice, she was wrong. How is that possible? My lords, I want you to remember, because it is in your file, the transmission from Kirigoya is in the portal, unless my learned friends are saying they have never seen the portal itself. Yeah? The registrar in Kirinyaga, Honorable Wanyama, writes a letter, yes, saying, good evening, kindly find attached the document for your attention. It has a time to the Chief Justice. It is on the 18th, and it is 15:45. It is 15:45. It is 3:45 in the afternoon. So when counsel repeats again and again, things were done at night. Well, a lie can go halfway around the world before truth wears its pants. It is not true. It is not true. The registrar sends the order at 3:45 in the afternoon. I stop there so that my learned friend will continue.
Thank you. My lords, I will take it up from there, and I will dive right into the constitutional questions. The application before you for challenging the empanelment of this bench addresses itself, my lords, to the powers of the Chief Justice under Article 161, 2A, B, that establishes the office of the Chief Justice as head of the Judiciary and of the Deputy Chief Justice as the Deputy Head of the Judiciary. And conversely, my lords, to Articles 163, 1B, that again provides that the Deputy Chief Justice shall deputize the Chief Justice and be the Vice President of the Supreme Court. My lords and your ladyship, it is now beyond peradventure, and again quoting from the CTS, that